first is the constitutional principle of the separation of powers, and the second is no more than a pragmatic view about the evidential value of certain judgments of the executive, whose force will vary according to the subject matter. He then refers to Lord Hoffman's speech in Rahman and quotes from it. And if we go over the page 509, and it's paragraph 54 of the quotation, you can see there that Lord Hoffman says it does not mean that the whole decision on whether deportation would be in the interests of national security is surrendered. And then 4 or 5 lines down, the factual basis for the executive's opinion that deportation would be in the interests of national security must be established by evidence. Again, that is something that I will be coming back to, because what you have in this case is Ravek's opinion that the bespoke process is better than the RMB. And that is obviously something that you're going to be looking at to see whether or not the reasoning given is clear, logical, and convincing. And one of the ways in my submission that you're going to want to do that is by looking at their own evidence, which you're perfectly entitled to do, as these cases show. And then just one more quotation from Lord Hoffman, which is on the evidential issue. And it is also, I think, at paragraph 24. I've just lost my note. Just give me one moment. Actually, my lords, I don't think I need to show you that, so I'm going to move on. And I want to just end the legal section with this. The fact-sensitive approach that we've seen in a number of these cases is consistent with the approach regularly taken by courts when they have looked at the facts and they have rejected attempts by the government to invoke some absolutist deference principle in contexts where the court is the ultimate arbiter. And there are 2 examples in the bundle, which I may come back to in reply, but I just invite you to note them for now. The first one is Rwanda in the Supreme Court, and that's Authorities Bundle 2, tab 27, page 999. And the question in that case, as my lords may recall, was whether there was a real risk of refoulement, which was a matter, just like whether there's a good reason to depart from a policy, for the court to assess. And I just invite you to note paras 51 to 52 of the Supreme Court's judgment, which is page 1019. In essence, the court was required to make its own assessment, attaching appropriate weight to the government's view. And then also paras 55, 6, and 7. And then the other illustration you have is the Attorney General and BBC case, which is Authorities 2, tab 25, page 969, and it's paragraph 29 that's relevant there. As I say, I may come back to those in reply, but they make the point, which
Can you give me that reference again?
AG and BBC, it's paragraph 29, it's Authorities 2, tab 25, page 969. So they make the point that is already made by Carlyle about the extent of the weight or deference that may be appropriate, and not to assume that it has the sort of general application that the government often claims that it does have. My lords, on the respondent's notice, I've already addressed the case law at some length, but can I just make 3 short concluding submissions on it? First of all, Munjaz is obviously binding on this court, and we say that it makes it very clear that the test is not Wednesbury rationality. The second point is that the respondent has not identified a single authority which supports its position, and the judge noted that in the judgment at para 157. And I've already addressed their purported reliance on Begum, which they're misreading. And then the third and final point is as I have said throughout showing you the cases, that the invocation of constitutional principle and concerns about democratic accountability in particular are not engaged here. The respondent's position appears to be that whenever there's a discretion, and if convention rights are not engaged directly, then you're in the territory of rationality.
One
159,
yeah.
162, 175, and 176. Those are the key paragraphs. Now, in terms of the structure of my submissions, what I want to do is just introduce the key documents, and I may be able to take this quickly if the court is familiar with them. I just want to make sure that you have seen the parts that I want to show you. And then I'm going to flag, as I've been saying, the purpose, content, and context that we say the court should be looking at when doing that interpretation exercise. And I then want to make submissions on what we say are 3 interpretive errors that were made by the judge. In terms of the documents, if I can start there, obviously the court will have the fact that the most important document in this case is the 2017 terms of reference. That was in place when the February 2020 decision was made. And Sir Richard Mottram says that the 2017 version, although less detailed than the 2021 version, does not differ in any significant way in terms of the role of RAVEC and its approach to its remit. That's Mottram 1, para 10, supplementary bundle, tab 2, page 37.
And as electronic reference for that. I mean, if you can give me electronic
I think it reference. Is. I think it's 37. So the page number I give you should always be the electronic reference.
In the supplemental or core?
Supplemental, and it's tab 2. 37. Supplemental, page 37.
Okay, thank you.
And my lords know that RAVEC has made decisions about the appellant since 2021, and so we submit that although the focus of your analysis is obviously on the 2017 terms of reference, the 2021 terms of reference are plainly relevant in informing your analysis regarding the decision-making process. Both of the terms of reference...
I thought we were only concerned with the decision of the 28th of February.
And we see the significance of their input into the terms of reference. Why does that matter? It matters because it shows that this is not a merely advisory document. It is far greater significance than that, because you can see that RAVEC itself was, in my submission, taking on board the views of undoubtedly experts to inform what it was doing. And we will say in due course that that is similar to the consultation that you saw in Munjaz, which led to the code. The consideration of the content in a careful way. Now, I want to go through each of purpose, content, and context. I hope I can do the first two quickly because it's just by reference to the documents themselves. The purpose of the terms of reference is to set out who RAVEC is, what it does, and the process that it follows to make decisions. And we see that from para 6 and para 20 of the 2017 document, and paras 2, 6, and 7 of the 21 document. And in terms,
I find that very helpful without going to the document.
my lords, I'm very happy to take you to that. What I was going to suggest, but I see that my Lord Master of the Rolls is working only electronically. The most helpful thing to do is to have them both side by side, which you're not going to be able to do. There's a little bit of flicking backwards and forwards otherwise. I don't...
Just explain why the 21 makes any difference. I mean, perhaps naively, I thought that you relied on the sort of mandatory nature of the requirements for a B.
Yes. That mandate
is actually the same.
It's exactly the same, precisely so. Why do I rely on the 2021? It's because of the EC. That document is part of the 2021 terms of reference. Why do I rely on the EC? The EC tells us why we need the RMB. You don't get that purely from the face of the 2017 terms of reference in the same way. You get some information.
Can we look at it?
The evaluation criteria, my lord.
Yes.
Yes, of course. It's page 173. Well, there are a number of paragraphs that I want to show you about this, but perhaps the most critical, if you go to paragraph 5 on page 174, the 2016 TESH review is currently the key document underpinning the principle that RAVEC should make decisions based on an evaluation of the risk analysis conducted by the RMB. TESH differentiates between analysis and evaluation in the following way. And you can see there's a quotation from paragraph 16 of the TESH review. And what John Tesh said is that the best risk management processes encompass but make clear a distinction between, and then you'll see that there are two things. So first of all, you have risk analysis, and the next paragraph, you have risk evaluation. Now, risk analysis is described as an objective, dispassionate inventory of what the risks are, including what would have to be reckoned with in terms of the impact and what the associated likelihood is. Now, pausing there, that's what the RMB does. We then see risk evaluation. That's a policy-making process in which social values and risk tolerance levels are factored in by ministers and officials in order to decide about the objectives of policy, what measures can or must be taken to achieve those objectives, and whether the residual risk is tolerable. That is what RAVEC does.
Yeah.
And then if you, since we're in this, perhaps I should just show you a few more of the passages. You can see in paragraph 8, well, standing back, I should say, what they're doing in 6, 7, and 8 is explaining essentially that they need to develop the risk evaluation framework. So the bit that RAVEC does, they're trying to develop in this document, not the bit that the RMB does. And they're explaining in paragraph 8 why that framework would help. So you can see, to ensure that decision-making processes are applied consistently across the cohort of protected principles, ensuring that different factors are not weighted disproportionately in relation to different principles. It will also strengthen the transparency. And then you have the heading criteria for evaluation, where they then go on to explore that very thing. And you can see that they say, worth exploring each of the criteria for evaluation set out in TESH. And my lords, this sentence, which understandably I put great emphasis on, the description of the RMB, crucial to that consideration, that is, of what should be in the criteria for evaluation, crucial to that consideration is the parallel review of the RMB.
When did that take place?
When did
the review? You referred to TESH.
Yes.
And it was 2016.
It was 2016. I don't believe that we know the date of the RMB review. You can see that it's described in some more detail later on in that paragraph. I'm obviously not going to continue reading out, but you'll see.
What I was puzzled by is paragraph 8, which says developing such a framework, obviously in the future, should also help assure committee members that decision-making processes are applied consistently, etc.
Yes.
So, I mean, this is all forward-looking, is it not?
Yes, it is, as far as risk evaluation is concerned.
Yeah.
But we're not. But my lords, I'm not troubled by that, because I'm not asking you to look at how RAVEC itself has evaluated the protective security. That is not part of my challenge. My challenge is the process that RAVEC followed before that. Because what you see in the terms of reference is that RAVEC's risk evaluation has got to be based on the RMB's risk analysis. It's got to be based on it. They're not done side by side. They're not, one is not done as an advisory, oh, well, if you want to ask the RMB, then by all means do. No, it is a principle, that's how they describe it themselves, that came from the TESH review. And that's why when the judge criticized my referring to the words in the document, the will, we'll see that in the key tasks, the executive committee will, and then refer to getting the report from the RMB. It's not just a fixation on the language, it's because we have a rationale. And the rationale is not just that the RMB is a distinct body with distinct expertise, but it's doing something different. And that's why I say this document matters, because it supplies us with the rationale. This is
It analyzes and supplies detail as to the risk in broad terms. So without them, you don't know what the level and nature and a lot of other things about the risk. Correct?
yes, the objective dispassionate inventory.
What I think will be said against you is that the decision Ravek was making in this case was what was the consequence of the claimant stepping back from royal duties and going to live primarily abroad,
Yes,
as regards further protection being provided by Her Majesty's government
yes,
for him when he came to England. And that is not affected on one analysis, I think it's said, by the level, the absolute level of risk or the nature of the risk. Because what they say, as I understand it, is there was put in place a process that whenever he announced his intention to come to the UK, some evaluation would be made of what for and where and why and how. And then risk might be relevant. But this was a decision as to the principle of whether, I'm going to use the wrong language, but blanket security should be provided when he was overseas under
yes.
the Ravek process.
Yes, that point.
And therefore, it said, well, we're confusing apples and pears. The level of the risk is obviously critical when you come to consider what kind of security you're going to provide and the type of risk and so on. But this wasn't the question they were deciding. They were simply deciding whether he was within their cohort, and that's something for them.
It's not for them,
Right.
in my submission. The terms of reference, and we've slightly digressed away from the structure that I was following, but the terms of reference, the reason why it's so important to look at them is they identify who is in the cohort. And can I just say, the word cohort is really apt to mislead.
It's apt to mislead, but I won't use it again.
Well, I say that, my lord, because if you look at the submissions and the evidence, it is used a lot, but it is not always clear what it means by the person who's using it. So I'm going to try and be more precise and not use that word cohort. Well, I'm going to say who is within Ravek's remit.
Right.
Okay, that's the first question. And the answer is members of royalty and public figures. And I said this to Mr. Justice Lane, I am not within Ravek's remit. Clearly, it's got to be someone who comes within that description. And we have evidence, and I will take you to it in the closed session about what that means. So that's how you get. That's how you.
That's not not about you. It's not controversial to say that the claimant is within the remit of Ravek, is it?
Well, it shouldn't be.
Stepping back from royal duties.
Well, precisely so. That's my point, my lord.
Well, they say that it's within their remit because they say they're going to consider what they should do whenever it comes to the UK.
Exactly. This is not a case where the appellant has been knocking on their door saying, let me in. They have let him in. So that is the remit question. Once you're in their remit, the terms of reference say that there are two questions for Ravek.
Yes.
One is whether that person gets protective security. So being in the remit doesn't mean that you get it. They still will consider whether or not you should.
Yes.
And then they will consider, if you're going to get it, what you should get. So all of that has got to be considered. Now, going back to my lord's point about the point that will be taken against me. So Richard's evidence is that when there was the change of role from full-time working member to not being a full-time working member,
Yes.
his evidence is, well, the terms of reference don't apply to the appellant. We don't have to make our decisions under the terms of reference. And that's paragraph 14 of Mottram 1. Now, that in my submission is wrong. You cannot do that as Ravek. He is obviously within your remit. He is a member of the royal family. You have accepted that he is within your remit because you are considering his
Just give
case.
me the page reference for SRM. I'm calling him SRM 1, paragraph 14.
If you can give me one moment, because I've
Supplemental bundle, page 38.
stepped away. Thank you very much.
This is a non-confidential paragraph, is it?
Yes, it is. And it is perhaps if I can just show you from the top of that page, he describes the essence of implementing the policy. That's the government's national risk assessment policy. And then he explains that there are two guiding principles. You see what they are.
Sorry, I'm not seeing two guiding principles.
So
Paragraph,
this is paragraph 14, but it continues on page 39. I thought,
sorry, I'm in the wrong place. I was confusing pages for paragraph.
not at all, my lord. So it's page 39.
Yeah, got it.
And he says at the top of that page, he refers, you can see, to the government's national risk assessment. And he says the essence of implementing this policy in the area of protective security was that, and then there's the first guiding principle, which is essentially where risk is sufficiently significant in terms of likelihood and impact on the interests of the state. And secondly, proportionate protective security measures should be provided at public expense appropriately to mitigate that risk. He then says, within these guiding principles, it was for Ravek to determine which individuals were within the cohort, and you see what I mean about the use of that word, for which it took responsibility for the provision of proportionate security measures. And this cohort changed over time as the roles of individuals changed and as security threats evolved. Just pause
In
it.
that sentence, cohort means the people who satisfy 1 and 2.
Exactly.
Yes.
Exactly. But sometimes it's not used in that way.
No, well, it is here.
Yes, and this is part of the problem. But anyway, moving on, he says it follows that Ravek did not produce nor was governed by a form of overarching guiding policy document which sets out who is to form the cohort and in what circumstances. There was no such document. Now, I accept that, of course. What that means is when Ravek's considering the whether and the what, the evaluation bit that we saw, there isn't something which explains in detail how it's going to do that. We have the guidance in the evaluation criteria, but we don't have a document setting it out chapter and verse.
Right.
And then he goes on. I and the members of Ravek followed the guiding principles as set out above and reached decisions in individual cases in a flexible and context-sensitive manner accordingly, including by reference to how potentially analogous cases had been handled in the past. And this is the important bit, my lord. When the claimant refers to Ravek's policy, it must be understood in this light. In particular, I should note that the 2017 terms of reference do not specifically address the responsibilities of Ravek in relation to an individual whose status has changed and no longer falls within the cohort of principles. That is clearly a matter for Ravek, but it is not a matter guided by the 2017 terms of reference. So what he's saying,
So do you disagree with that?
I say that's wrong.
Wrong in what sense? It's
That's
evidence.
not what the terms of reference say, and it's not what, in my submission, properly interpreted the terms of reference mean. What they mean, as I've said, is if you're within the remit, Ravek has got to comply with those terms of reference. I mean, the name of the document is a clue. It's terms of reference for Ravek. It's explaining how Ravek needs to approach its decision making. It is not saying.
Well, just pause for a moment. I completely see the sort of blanket nature of the submission that you know, terms of reference are terms of reference, and therefore what you do are guided by terms of reference. That's all very logical, if I may say so. But I think the problem here is this has never happened before. So there's not a part of the terms of reference which say what does RAVEC do when a previously active member of the royal family undertaking state duties decides to step back and go and live abroad. There's not a section that says
No, there is not.
What I understand Sir Richard to be saying here, and I may be wrong, is that actually there's no specific part of RAVEC that addresses the responsibilities of status change, etc. So we were flying free in reaching a decision as to what to do. I think he's not saying we completely ignored terms of reference. He's just saying we didn't get specific guidance.
Well, my lord, I may be corrected by the respondent, but my common ground, you recall I began with this.
Yes.
As far as I understand it, it is common ground
Yes.
that Sir Richard did not consider that the 2017 terms of reference applied to the claimant. So
Well, I think that's too broad a statement, isn't it? I mean, of course they applied to the claimant because they applied to everything the RAVEC did. What he's saying is what he's saying is precisely in this sentence. In particular, I should note that the terms of reference do not specifically address the responsibilities of RAVEC in relation to an individual whose status has changed and no longer falls within the cohort of principles. Now, I understand, but he's used that term here to mean people who are going to have protection.
yes,
So let's assume he still means
yes.
that. And that's clearly a matter for RAVEC, but it's not a matter guided by the terms of reference. So that's what he means. He's not saying the terms of reference don't apply to the claimant, or he doesn't have to apply the terms of reference, or even that he didn't consider the terms of reference. He's just saying in this particular decision, I don't get any specific help from the terms of reference, isn't it?
Well, my lord, I haven't understood the respondent to be interpreting it in that way.
Okay. Well,
But as I say, I may be corrected in that.
I should be corrected if I'm wrong as well. Yes.
My lord, it would make things a lot easier if what my lord is saying was actually the position. Part of the reason I'm having to fight this is because of the way it's been defended, which is to say, we didn't apply this at all. You completely fell outside of the process. But can I just deal with this idea of flying free? And I will come back to it in the closed session. RAVEC were not flying free.
No, of course not.
They
It's
were
a
not.
very bad expression.
No, it's very helpful, if I may say so, as a shorthand for this idea that essentially there wasn't a precedent. They were not flying free. And that's why this whole structure of how they approached it, what they were thinking about, how they explained themselves, we'll come on to the contemporaneous document, it matters. And so, my lord, going back to this point that you made to me about it will be said against you, well, this is all very interesting, but this was novel and unique and different.
Yeah.
In my submission, no. That there are guiding principles in these documents and in the practice of RAVEC that show, as I said, that the bespoke is in fact different, unjustified and inferior. And we need to get into the
The
detail.
bespoke is what?
Different, unjustified and inferior.
Oh, I see. You mean this bespoke?
This bespoke, yes.
Yes.
May I just go back a little bit? Because what I was doing was just going through the two terms of reference documents and giving you some references. Can I just make sure that you've got them? And I'm mindful of the fact that my lord wishes to see the specific documents, so I don't want to skip over them. But can I show you in particular just two passages in both of them? So the 2017, this is in terms of what RAVEC does, and it goes to my point about the will. So this is paragraph 20, and it's the third bullet point. So it is page 171.
Yes.
So that's in terms of what RAVEC does. Executive committee will evaluate the risk analysis conducted by the RMB in order to, and then you get the who and the what. And the same provision is in the 2021 terms of reference. It's page 178. It's now paragraph 6, and it's now the first bullet point. And again, just to make good the point I've made about the remit is members of royalty and public figures who are present in England, Wales, and Scotland. And again, if I can just show you the 2017 terms of reference, you see the word present on page 168 in para 3. And again, I hasten to add, I'm not saying it's just the words. I'll come back to give you the colour later, but we see present, and then in paragraph...
Oh, you're going too quickly.
Page 168.
Yes, I'm on 168. I'm in paragraph 3.
Chair is responsible for decisions for individuals who are present
Oh, I see.
in England, Wales, and Scotland.
Right, yes.
And then if you go to page 171,
Yes.
you can see there, paragraph 20,
Mm-hmm.
first bullet point, exercise the national policy.
Yes.
Again, that same members of royal family and public figures. And then if you go to the next page,
Yes.
172,
Mm-hmm.
if an individual who falls within the remit, that's why I've used that word,
172,
paragraph 23.
23.
So those are just the passages to make good what I've said about who is in the remit. So it's member of royalty who is present in England, Wales, and Scotland. And then we
Well,
see
what does that mean?
which bit, my lord?
Present.
Here. They don't have to live here. They have to be here.
So what if they're not here most of the time? What does it mean, present? Does it mean present all the time, living here, mostly present? What does it mean?
Well, in my submission, it means enough for my purposes, which is it applies when the person is here. So this is
Whenever the person is
whenever the person is here. This is again my point about remit, the flying free. This is why the terms of reference don't exclude somebody who is in the appellant's position.
But they didn't, did they? I mean, I understand your point about different, unjustified, and inferior, but they didn't exclude him, did they? Because he was going to be abroad sometimes, or even to live abroad.
No, but this goes back to paragraph 14 of Richard Mottram's statement. This is the question my lord put to me. Well,
Yes, no, I see that, but I'm not sure it does get back to paragraph 14. I mean, paragraph 14. Anyway, look, I'm just speaking for myself.
I understand, my
First
lord.
impressions, but it seems to me to address the question of the decision they were taking about the claimant when he stepped back from royal duty.
Yes.
And he says, and I understand why he says, because I've read this thing in its whole, he says that that didn't give him guidance as to how he was to deal with that particular question. I can see why you say, well, it sort of does, or it does, particularly as regards the RMB. I mean, I get the argument. But I think you may be overinterpreting his paragraph 14 if you say that it says he just figuratively threw the terms of reference away and didn't consider them, because the terms of reference are the whole thing. They're the only thing they've got to go by.
Yes.
He said, but just for this particular question, I didn't have much help from it.
Yes, and I may go back to the grounds of resistance to show you how the respondent has put it, because as I say,
Yes.
they have, as I understand it, put it in far more extreme terms, which is we didn't operate under the terms of reference for you, and it's linked to why they didn't do the RMB, because they say we didn't have to because we weren't operating under that. They obviously go on and have an explanation as well, but one of the defenses is this just doesn't apply to you. This whole system just doesn't apply to you because you're not in the cohort, as they've put it. Can I just show you the passages in 2021 now, which start at 177?
Well, just before we do that, Ms. Fatima, can we go back to 2017, paragraph 3, which you were just showing us? Individuals who are present in England and Scotland.
Yes.
It seems to me, looking at that as written in 2017, nobody was thinking about the possibility that an individual clearly within, I'm calling it cohort, but clearly within the remit, might go and live abroad. And this covers individuals who are present in England, Wales and Scotland, special arrangements for Northern Ireland, and decisions on protective security for any overseas travel from the UK.
Yes.
There's something called the Royal and Ministerial Visits Committee.
Yes.
But there's nothing there about somebody within ABEC protection who goes to live abroad.
Which is why, my lord, I'm going to address you in the closed session about why I'm not saying, just look at this, don't look at anything else. I'm saying, look at this, and then let's look at everything else that goes around it. Because when you have all of that context, this means what it says. It means it's somebody who is present. And so I entirely take your point that looked at in a vacuum, that would and in my submission, it will be purpose, content, that is the text, and context. So, of course, when the court is actually engaging in that interpretive analysis, you do look, in my submission, at the context. And that can include outward facing, internal facing, and so on. So, my lord, I was just going through this section, which starts now on page 835. It's the heading just above paragraph 52, to say that you can see from the pages that follow the interpretive exercise that the Supreme Court did. It goes all the way up to paragraph 74. But I wonder if we could just stop off and look at paragraph 69 first of all. Paragraph 69 is the one that I've identified to you as the basis for the propositions I've given you about Hemati. It is on page 100 and 840. If I could just ask you to read that before I make some points.
Is that the one that you referred to in relation to 3 or 4 of your propositions?
Yes, my lord.
69. Let's
Yes.
read it.
Yes.
I mean, you can read it out. It always helps me if you read it out. I know that.
Certainly. I'm conscious that my lords may get tired of hearing my voice,
Well,
but
except that it's only 10 lines, and it may be important for everybody else in court
Yes.
to hear what you're saying.
There can also be no doubt that in this jurisdiction, a policy statement such as Chapter 55 of the EIG has significant legal effects. I have referred to these at paras 50 to 51 above. In broad terms, and as Lord Justice Laws explained in Nadaraja, where a public authority has issued a promise or adopted a practice which represents how it proposes to act in a given area, the law requires that promise or practice to be honoured, unless there is good reason not to do so. Moreover, the court is the final arbiter of what a policy means. There's then a reference to Kambadzi and Mandalia, which we'll come on to look at. It is also well established that compliance with such a policy is enforceable by individuals before the courts. So My lords,
So you say that's very clear and comprehensive.
clear and comprehensive, and first of all, setting out the Nadaraja principle, setting out the court as the final arbiter, but then it's a nil return, if you like, in terms of Hopkins. There's nothing there about a general presumption. And this would be the sort of case to say it, because it's an immigration case. And as we'll come on to see, the respondents say that planning and immigration are examples of where the presumption that they rely upon bites. So nothing here. And as I said in response to a question earlier, my lords, it wasn't even cited in argument, let alone referred to by the court. The next authority is Mandalia, which is 2015, and it's bundle 1, tab 12, and electronically it should be page 475.
This is earlier, isn't it?
I'm so sorry, my lord, I didn't.
This is earlier.
Yes, this is 2015. And again, just as a reminder, I'm citing it for court being the final arbiter and also the no Hopkins. Again, if I could just take the facts from the head note on page 475, you can see from the top of that there was an applicant for a UK visa and he failed to provide evidence of sufficient funds for the requisite period. You can see that between letters E and F. He only provided evidence for part of that period. And then we can see going down to G that there was a process instruction given to border agency caseworkers, which required that in certain circumstances they ask further questions from the applicant before determining the application. And no such request was made to the applicant. His application was refused. So pausing there, my lord, this is an example of that internal facing policy that I referred to earlier. If we go to page 478.
It was unpublished process instruction.
Yes.
Yeah, so which page?
Page 478. This is the judgment of Lord Wilson for the Supreme Court. And you can see the question that the court was considering between letters B and C. The question is, did it act unlawfully in refusing his application without having first invited him to supply a further bank statement and so on?
Right, I'm not not with you where you are. Which paragraph?
It's the continuation of paragraph 1.
Oh, right.
And it's page 478 between letters
Between B and C. Sorry,
Yes.
I thought you said D. Yep, got it. Thank you.
The relevant legal principles start at paragraph 29 on page 484. And you can see from the top of page 485, and again it's between B and C, that Lord Wilson refers to the applicant having the right to determination of his application in accordance with policy. Now generally taken to flow from a principle no doubt related to the doctrine of legitimate expectation, but freestanding, which was best articulated by Lord Justice Laws in Nadaraja, and we there have set out that paragraph 68 from Nadaraja.
Yes.
And then the key paragraph that we rely on is 31, which is at the bottom of that page. And if you could have a look between letters G and H, please.
Yes.
Lord Wilson says that the Secretary of State does not say there were good reasons for not following the policy, but that properly interpreted the instruction did not require the caseworker to alert the applicant. And he then says that the search is for the proper interpretation of the process instruction. You see that at the bottom of the page. No more and no less, he says. Indeed, in that regard, it is now clear that its interpretation is a matter of law, which the court must therefore decide for itself. And over the page, previous suggestions that the court should adopt the Secretary of State's own interpretations of her immigration policies, unless it is unreasonable, made, for example, in Gangadeen, are therefore inaccurate. And we say again, my lords, that this paragraph shows that the respondent's reliance on Hopkins as creating a presumption of general applications is not a good one. And just so the court has the answer that was given to that question that we saw in paragraph 1, it is in paragraph 36 on page 487. And you can see that the conclusion reflects the fact that the Supreme Court interpreted the policy for itself and said that the process instruction obliged the caseworker first to have invited Mr. Mandalia to repair the deficit in his evidence. My lords, this case illustrates the point that procedure may in itself provide a benefit, because the right to file more evidence in this case, in Mandalia, was part of the procedure, but it was also a benefit. And similarly, we say in the present case before this court that the need for an RMB assessment is part of RAVEC's procedure, but also a benefit. And that is relevant when we come on to look at the good reason part of the analysis.
Do you think it could be said against you that you're trying to put public law into a very inflexible series of boxes, which the judge at paragraph 178 and following declined to do in this case because of the context? And he made that criticism effectively of your submissions below. I mean, the cases you've shown us so far are all immigration cases with policies that apply to, even if not published, apply to hundreds of thousands of people. And a process in immigration does have to be fair. All processes have to be fair, but the processes don't necessarily have to be the same in every type of case, because fairness is not put into little self-contained boxes. And I'm just interested to know whether you would accept the criticism that so far you're adumbrating really quite inflexible monochromatic rules that are applicable to everything called a policy. And we've, for the avoidance of doubt, looked very carefully at the underlying documents in this case. And the so-called policy is, in fact, called terms of reference.
Yes.
And is quite short and not the same anyway as many of the immigration policies many of us have had quite a good opportunity of looking at. What do you say about applying these sort of tightly drawn principles in this situation?
My lord, I would not accept that criticism if it were to be made. And the reason for that is I don't accept the characterization that what I've described to you are tightly drawn boxes. What I've described are principles or propositions that guide the way the court should approach this particular case, involving, as it does, the interpretation of a policy. I entirely accept that each policy will be different, and what it requires in terms of the court's consideration will be different. And I am going to come on to look at what, on the facts of this case, I accept you should be looking at. Contrary to the characterization in the judgment, I am not pressing on you a mechanistic, literal interpretation. And the reason for that, and obviously I will come on to develop this, is I don't say that we get the meaning from the four corners of the document. I don't say that. That is why this isn't about boxes or tight adumbrations, which may be a straitjacket in a public law context. This is to say, and as my lord said, it is accepted that the court is the final arbiter, subject to the difference on Hopkins. The question is how you go about that job. And in my submission, you don't defer to what Ravek thinks the policy means or says, but that's one end of the spectrum that the respondents are pressing on you. I'm not going to the other extreme end of the spectrum to say, well, just look at the words on the page. Don't look any further. Look at it as if it was an act of parliament or a contract, although, of course, even in those cases, one doesn't just look at the words on the page. I am going to be inviting you to take a much broader lens, to look at the purpose as well as the content. And when we come to look at the context, I will identify 4 strands that I say are relevant and engaged. And my lord will see in due course that those 4 strands reflect the world that we're in of protective security provision, which is obviously different from planning or immigration. So my lord, I would not accept the criticism for those reasons.
Okay, thank you.
I want to move now to Raisi, which is 2008. And it is bundle 1, tab 6. It's page 224 of the electronic bundle. And you can see from the head note, letter G, that the claimant applied for compensation for detention.